General, I'd like to ask the government's views of the major questions doctrine that a number of my colleagues have asked about. And as I see it, there are sort of two ways that such a doctrine could operate. One is with respect to ambiguous statutes, ambiguous either because they're vague or because there are statutes that seem to have conflicting provisions, where they point both ways. And then the major questions doctrine is an aid to interpretation of that statute. It's essentially a kind of clue about how you should interpret a very difficult to understand statute. And the second way is there's really nothing difficult to understand about this. The agency action falls within the scope of the statutory authority. There's just no question that it does. And yet, because the agency action is kind of a big deal, we're just going to ignore the fact that it falls clearly within the scope of the delegated authority and say that, notwithstanding that that's true, Congress has to re-up it. So I think I'd like you to talk about those two versions of the major questions doctrine with respect to this rule. What do you think of those two versions, and which of the versions potentially applies here?
I think that perfectly encapsulates the two versions, and we think that this court's precedents clearly demonstrate that it's the first version that you articulated is the way that the court has previously considered economic and political consequences. So it's never been the case that the court has started at the outset by saying, does this seem like a big deal? Does this agency action have a lot of consequences? And then use that as a basis to depart from the plain language of the statute, or to say Congress has to specifically authorize it. We're not going to give the statutory text its ordinary meaning. Instead, in the cases where the court has looked at those kinds of consequences, it has always identified a conflict with other express statutory language, a conflict with other statutes that Congress has enacted that directly address the issue at question, or a conflict with the entire structure of the statute such that it would be unrecognizable to the Congress that enacted it. And it's only been in those situations where the court has identified a textual and structural problem with the agency's interpretation in the beginning, using those traditional tools of statutory construction, that the court has then gone on to say that its interpretation of the statute is confirmed by the economic and political consequences that would ensue. So I think it would be a sea change for this court to reverse the order of operations as the applicants are asking for here, and to start off by asking, does this seem like it has economic and political consequences? And it would ultimately do a disservice to principles of the separation of powers and to Congress's ability to have its clear statutory enactments, even if they're broad, given the effect that they have.
Justice Gorsuch.
The Supreme Court heard the oral argument in Helix Energy Solutions v. Hewitt on Wednesday. The case is on employment law and overtime pay. Michael Hewitt, who made over $200,000 a year on a day rate, believes he is owed overtime by his previous employer, Helix Energy Solutions, as he worked 84 hours a week. During the argument, Supreme Court Justice Elena Kagan questioned the attorney for Helix Energy Solutions about the meaning of salary basis. Kagan said the definition of salary basis as described by the company was, quote, a clunker of a sentence.
I'm not sure I get it, Mr. Clement. So 601 sends you to 602 because 602 tells you what salary basis means. That's, we can all agree on.
Okay, but can I just stop you to say?
Not
but
really.
It's okay.
So what does salary basis mean according to 602? And 602 is a clunker of a sentence, right? So you have to, read it pretty carefully. But there's this language here which says on a weekly or less frequent basis. And the question is, should we understand it the way I think Justice Sotomayor was understanding it, is the predetermined amount calculated on a weekly or less frequent basis, in which case he doesn't get it because his pay is calculated on a daily basis. Or does it mean something else? And if so, what else could it mean, given this language that's right here in Section 602 starting us off, that the predetermined amount should be on a weekly or less frequent basis?
So, Justice Kagan, the sort of frequency of the basis or week or is not modifying calculation, which is not a word that appears in 602 at all. It's modifying the word received, which happens to dovetail perfectly with the word in 601, which is paid on a salary basis.
Yeah, so I think that's what this depends on, is is what is the weekly basis modifying? Is it modifying the predetermined amount, or is it modifying the receipt? That seems right to me.
Well,
and you know, this is a clunker of a sentence, but I would think, given all the different ways that this regulation uses the idea of weekly basis, daily basis, you know, et cetera, hourly basis, et cetera, that what this regulation is talking about is how is your pay calculated? Is it calculated on a daily basis? In which case, you can still be exempted because you can go to 604 and be exempted, but you don't fit under Section 604. So if a daily basis, you can be exempted under Section 604. 602 says it's an exemption for people whose pay is on a weekly basis, and you don't fit that either because Mr. Hewitt's pay is not on a weekly basis. So you're out of 602, you're out of 604, you're out.
So a funny thing happens when you go to 604, though, which is it has this phrase, may be computed on an hourly, daily, or shift basis. And so I think if you just look at 602 alone, received means received and not calculated or computed. But I think that inference is strongly supported. This is not an agency that didn't know how to use the words computed or calculated. They used that in 604. So I don't think it's a fight between whether on a weekly basis modifies predetermined amount or received. It's really their position requires you to stick an entirely different word in the sentence, which is calculated.
How often did he receive pay?
He received pay on a biweekly basis, so every other week.
And in that biweekly, how much was he, what was the minimum he would receive?
He knew he would receive, if he worked 2 weeks during that period, he knew he would receive at least $963 times 2. Yeah. And if he only worked one, he knew he'd receive $963. And the regulation is explicit, which I think also underscores that it's not.
Go ahead.
Good. I mean, are you saying now that there is an interest and a compelling interest in racial diversity among other kinds of diversity? I mean, putting Harvard's, you know, whether Harvard should be more socioeconomically diverse, probably should be. But putting that, I mean, is there an interest in racial diversity?
I agree with my colleague, not a compelling interest that could justify a racial classification. But racial diversity is not a bad thing. It is a great thing. It is something.
But the whole premise of this, right, and, you know, we can talk about whether these programs are narrowly tailored, whether the universities have done enough to, with the use of race-neutral criteria. But the premise of your argument is that even if race-neutral criteria could not achieve the object, Harvard can't use race-conscious criteria. And that must be because you think it's just not important enough. Isn't that right?
I don't think that's right. So we have very detailed record evidence here that if Harvard just turned off race on its admissions process, it would still have 6% African Americans. I believe it's 9% Hispanics, so 15% underrepresented.
So you think like good enough. But how about if it were 2%? I mean, the nature of your argument is that it doesn't matter. That's what the nature of your argument is.
I disagree, Justice Kagan. It does matter because if you're below those numbers, then Harvard's probably discriminating in some sense, and it should stop. Or it's not reaching underrepresented minorities in the way that it should. Perhaps it should not.
Well, that's just fighting the question. I mean, the question is, you know, is there a limit beyond which you would say, oh, yes, if you can't achieve that level of diversity with race-neutral criteria, then you're allowed to use race-conscious criteria?
I don't think there's any level that justifies explicit racial classifications, but I'm going to fight the hypothetical one more time if you'll let me, because race neutral alternatives. No, I don't think I will.
So let me just go on and ask you a couple of other things. I mean, because this is, you know, to me, this is a lot of the argument here is about a university has a compelling interest in collecting a diverse class, including along racial dimensions, and maybe especially along racial dimensions, given the kinds of challenges that our society faces, in the exact same way that all the other institutions of our society does. So I'm just going to ask you some questions about that. If you're a hospital and you serve a diverse group of patients, is it super important to you to have a diverse set of doctors?
I don't know that the evidence about the diversity of doctors and patients or anything about the medical field.
It wouldn't matter, yeah. Okay, or maybe it would, you don't know. If you're a police department and you serve a diverse community, is it super important to you to have a diverse set of police officers?
I mean, I believe that's important if there's good evidence that a racial classification was needed. That has nothing to do with the educational benefits of diversity in universities. That's the interest that Grutter
Do you
upheld.
think that if you're a law firm, or if you're a judge, and you want to have a diverse set of clerks, do you think a judge can't think about that in making clerkship decisions?
Absolutely can think about it. This court's decision in Feeney says knowledge of race is not the violation. It is using it as a factor to distinguish him.
Let's say a judge says, I want a diverse set of clerks. That's, I want clerks who would, grade on any number of criteria, but I also want a diverse set of clerks. So over the years, people will look at that and they'll say, there are Asian Americans there, there are Hispanics there, there are African Americans there, as well as there are whites there. Can a judge not do that?
I mean, I think that is a admirable goal. I don't think a judge could implement that goal by putting a thumb on the scale against Asian applicants or giving a big preference to Black and Hispanic applicants. I think you need to treat people equally based on race, just as you're not going to hold my race against me in judging the quality of my arguments. I think racial diversity is important because it's a good metric to make sure our institutions are equally open. You can certainly be concerned about that. But the question is using racial classification, telling people that you didn't get the clerkship because of your race.
Yeah, but the point here is, look, everybody would rather achieve all our racial diversity goals through race-neutral means. Everybody would rather that. And that's certainly what our cases say you have to do. The question is, when the race-neutral means don't get you there, are you prevented from taking race into account in all those ways that I said? And I could add a dozen more. Businesses who find it necessary, in order to achieve their economic objectives, to have racially diverse workforces. I mean, I could go on and on and on. And the question is, when race-neutral means can't get you there, don't get you there, when you've tried and they still won't get you there, can you go race-conscious?
I don't believe so, Justice Kagan, and I think this court has already said in Parents Involved that racial diversity is not a compelling interest. It is the overall diversity of all kinds on college campuses. And this doesn't have to be hypothetical. We presented an alternative to Harvard that would achieve socioeconomic diversity for the first time, that would boost underrepresented minority representation, that would lower the number of white students on campus. And so we're talking not about no diversity and diversity, we're talking about 10% Black representation or 14% Black.
I take this to be the purport of most of your briefs, not putting aside the last 10 pages or so. But in your view, it really wouldn't matter if there was a precipitous decline in minority admissions, African American, Hispanic, one or the other. If I think there are some numbers in this case, but suppose that it just fell through the floor. Would it just, too bad?
Well, I don't think that it's going to fall through the floor if the university is actually committed to the broader diversity it wants. Because
right, I know you think that, and there's been obviously a lot of the litigation has been about that. How much will it decline, and you're expert and they're expert. But the logic of your position suggests that that really doesn't matter. I mean, the last 10 pages of your brief where you say, has there been narrow tailoring here, it matters in that 10 pages. But it doesn't matter if you're saying there's a categorical rule, no race shall be involved in admissions decisions, then it doesn't matter if minority enrollment or particular kinds of minority enrollment fall through the floor, does it?
If the application process is open and that is a result of the criteria that the university has elected to choose, and it's not discriminatory under this court's other precedents, then that is the educational decision the university has made. I doubt any university would ever make that decision. That has not been the experience, for example, in Florida, which is race neutral, has very similar demographics to UNC, and by UNC's own admission in this record, actually achieves better racial diversity as well as 50% greater number of programs.
Right, well, that
on
gets
campus.
us back to this question of what universities can do with what purpose to achieve racial diversity even without being explicit about racial classifications. But putting that aside, I mean, I guess what I'm saying is your brief, and this is very explicit in your brief, is like it just doesn't matter if our institutions look like America. You say this on page 11 in your reply brief. And I guess what I'm asking you is, Doesn't it? I mean, doesn't it? These are the pipelines to leadership in our society. It might be military leadership. It might be business leadership. It might be leadership in the law. It might be leadership in all kinds of different areas. Universities are the pipeline to that leadership. Now, if universities are not racially diverse and your rule suggests that it doesn't matter, well, then all of those institutions are not going to be racially diverse either. And I thought that part of what it meant to be an American and to believe in American pluralism is that actually our institutions, are reflective of who we are as a people in all our variety.
I think that's right. I think the reason that we think that and why that is a great American ideal is because we expect that the government is going to be open to everybody who wishes to apply, and that because merit and your worth as a person and your value as a contributory citizen is not correlated with your skin color. And so naturally, a government that treats people fairly and that makes opportunity open to all will necessarily see racial diversity. And indeed, that's been the experience
you said,
before.
and I think you're right to say this, you said to one of my colleagues' questions, if this didn't matter, they're spending an awful lot of time and money and anxiety doing something that doesn't matter. So let's presume it does matter. Let's presume it does matter that these programs have been understood to be necessary to ensure that these institutions have a certain level of racial diversity. And I concede what Justice Gorsuch says, that racial diversity and quotas, it's a little bit mysterious, but have a certain level of racial diversity that will enable them to get the benefits of all our many different peoples, and that enables American society generally to do the same.
Well, because I think one of the problems with Grutter is that it suggests that this is somehow costless, that if it's one factor among many and we can't identify, exactly how many points race is getting, although obviously statistical analysis does allow us to do that at some point, Grutter says it's not that big of a deal, it's always a plus factor and never a negative. But this is a zero-sum game. That is one of the problems with Grutter, is it suggests that the harm of racial classifications, which this court have always recognized are inherent and invidious of themselves, can be hidden or pushed down as long as race is just one of many factors.
Justice Gorsuch?
Tell me what I'm missing. 1331 says that district courts have jurisdiction over these claims, absent any other consideration. And normally we consider district courts bound to exercise their jurisdiction when they have a claim. Okay. Then we have the FTC Act that says cease and desist orders can be reviewed in the courts of appeals rather than the district courts. Those are the two statutes we have. We don't have a cease and desist order here. I would have thought that might have been the end of the game, and that the Thunder Basin factors would come in handy if we did have a cease and desist order. In that circumstance, then perhaps we would make you wait and consider all these prudential factors about interfering with agency proceedings. Again, what am I missing?
So I don't think you're missing anything. I think you're going to love Mr. Garr's argument later today. But what I would say is I do think if you go with that
It's simplistic. No, go ahead. Go ahead. Simplistic. We could.
I didn't like simplistic. Straightforward. If you
textual, maybe. How about that?
Textual, okay. Straightforward. All of those words seem to apply. Simplistic was a bad word choice.
It could have been worse. It could have been.
But if you go with that approach, then I do think that district courts are going to have to be ready to apply a whole bunch of fairly well-established doctrines of ripeness and exhaustion, primary jurisdiction, maybe abstention. I know, generally.
Don't they do that all the time? I mean, maybe that's simplistic, but.
They do that all the time. I don't think it's like entirely kismet, though, that if you step back and said, what would the result be of applying all of those other non-jurisdictional doctrines? Boy, I think you'd get to a situation that said, if you've got a claim that's wholly collateral, you don't get meaningful review, and the agency doesn't have any expertise, that's going to go forward to the merits in the district court. And if one of those or two of those actually aren't satisfied, then probably you're going to get tripped up by ripeness or exhaustion or something. So it would be a cleaner world. It would be a simpler world, a more textual world to go that route. But I think you're going to end up in kind of the same place, which is why, we're here happy to win on the Thunder Basin factors as well.
And then
Justice Sotomayor, anything further? Okay.
So this is just a matter of curiosity, but let's take two things to be true. One is that the right to control one's own assets is not itself a property interest, a sufficient property interest under the statute. And the second is that in a case like this, the $750 million is a property interest under the statute. I guess what I'm curious about is how did the Second Circuit, and I presume also the government, must have argued these things to the Second Circuit. Why did they go down this road? How did it benefit anybody to conceive of the property in the case as the right to control assets rather than to conceive of the property in the case as the contract monies?
Well, Your Honor, I can't quite speak to what everyone might have been thinking back when this originally began, but as I suggested, I think the Second Circuit might have gotten a little bit of a bad rap. The phrase right to control does appear in McNally, where the court distinguishes the theory in that case from a right to control.
So there's no set
theory.
of, whether it's a bad rap or, there's no set of cases that people thought, oh, if we define the property interest this way, we can get to a certain set of cases that we couldn't get to if we defined the property interest as the contract monies.
I don't think that was the original conception of it, Your Honor. I do think I don't want to suggest the right to control theory only appeared after McNally. It does have its genesis in some pre-McNally cases. And I think it's, to be perfectly candid, Your Honor, an easier way for courts or potentially prosecutors just to get at some of these things. Because if you just say right to control or deprivation of economic information is enough, maybe it's a slightly easier route to prove to a jury, for example, or to affirm on those grounds. But it is possible for that theory to encompass too much. And I don't know that it's really actually been subject to very much abuse. I won't suggest that it hasn't been subject to abuse in some isolated cases, but I wouldn't submit that we would expect a lot of
thank you. You've answered the question.
Yeah.
Justice Kagan?
You referred a little while ago to past administration's practice and said what you were doing was consistent with that, or at least that Texas's view would be inconsistent with that. And I wondered if you could give a little bit more detail on that. And I'll tell you just that it seems to me that you have a quite strong argument under 1231, but I'm not so sure of your argument under 1226. And so if you would address each of the two provisions and what prior administrations have done.
Yes, I would be happy to. So the agency has always implemented these provisions, which were added to the INA in 1996, in recognition that it retains its background principles of enforcement discretion. And so it has never implemented the statute with respect to 1226, 1231, or some of the other big ones like 1225 that you shall, as creating an inflexible mandate to go after each and every one of the non-citizens described in those provisions. And that has been constant. With respect to 1226C itself, the other thing that's been constant is what I was describing to Justice Alito, which is that DHS has long understood C2 to require mandatory detention in circumstances where we have pending removal proceedings and already have an individual in custody. But it has never interpreted that provision as requiring it to go out and arrest every individual who's described in that provision, both because that would be an impossible burden and because it's never understood the shall language, the bare use of shall, with respect to the take into custody provision to create that kind of inflexible mandate.
Thank you. I guess your stronger argument is where their removal proceedings have not been initiated. But how about, are there some circumstances in which there are pending removal proceedings so that 1226 kicks in, but you haven't apprehended the person? And are you then saying that you don't have an obligation to apprehend the person even while even once you've initiated a removal proceeding? Does that ever happen? Is that your argument? Why is it your argument?
Yes, so it's possible that that could happen in a circumstance, for example, where DHS encounters someone at the border who lacks papers, and so they're removable, and they're issued a notice to appear and have pending removal proceedings, but the agency isn't aware that they're a non-citizen described in 1226C, and then later gains that kind of information after the non-citizen has already been released, and therefore is aware of the information at that juncture. But I do want to be clear that it's not as though DHS has a database and an awareness ex ante of each and every non-citizen who might have a 1226C.
Thomas? Justice Alito? Justice Sotomayor? Justice Kagan?
Yeah, I wanted to take you back to my opening questions and then Justice Alito's question about how your case is different from my hypothetical. And maybe the way to sort of cut through some of this is to not make it a hypothetical and just ask about your client. So Mike and Mary go into your client. We love your graphics. We saw them someplace else. We love how this looks. Here's what we want. We want a standard site, our names, the picture, the hotels, the registry, you know, just that. And you say, okay, don't you?
Yes, assuming all the details line up with the message that she's willing to create.
Yeah, I mean, then they say, we don't want your scripture. That's all right with you. They don't have to have scripture.
No, they don't have to.
They can just have a standard site, right? Okay. So now it's not Mike and Mary. Now it's Mike and Mark, and they want the identical site. We saw Mike and Mary's site. We loved it. We're getting married, all they want to change is the date maybe, or, their names, whatever. We loved it. And they don't get it. And the question, and you say no, right? You wouldn't be up there if you weren't going to say no, right? They can't get that site.
Yes, because the same words can even convey different meanings.
Yeah. So then, the difference is one couple is opposite sex, one couple is same sex. How is this, what are the different meanings? What is the speech that your client is expected, is required to provide in the way I expressed it to you?
The purpose of the websites is to celebrate an upcoming wedding. It's to announce a wedding. And
it is to announce a wedding. This is a standard site, there's not a whole lot of, gosh, isn't this great? It's just like, here's the registry, It's announcing the wedding, it's announcing where to get the hotel reservations and so forth, right? So what speech is being, that's what websites do, just like it's what invitations do, right? So, next we'll have the stationer up there saying, we print the stationery, right? that would be the same. It is announcing the wedding. What's the speech that's been required of your client that I'm going to have lots of questions for these guys too, but in that context, what is the speech that is required of your client that would violate the First Amendment?
She believes that same-sex weddings contradict Scripture, and she's announcing a concept of marriage that she believes to be false. And in addition to that,
but that just sounds to me like I would be participating in a wedding, I would be, lending my services to a wedding. As Justice Sotomayor suggested, the florist, the baker, and the guy who provides the chairs are also providing the services in a wedding that they don't like. So why are they any different?
the person providing the chairs isn't providing speech, but when you are engaging in symbolic speech, whether that be through the creation of a custom wedding cake or a custom wedding website, you are creating speech.
Even though the site doesn't say anything about that. It doesn't say, wow, gay marriage is a wonderful thing. It doesn't even say, you know, we're here to celebrate this wonderful marriage, in my hypothetical. It doesn't even say that.
Again, the announcement of the wedding itself is a concept that she believes to be false, and the entire purpose behind the compelled speech doctrine is to avoid these ends by avoiding these beginnings. It's to ensure that individuals don't speak messages that betray their conscience, and that applies just as much to the Democrat as to the LGBT or the Black cross sculptor.
Thank you. Ms. Wagner, unless you're not through with that, sorry.
I'm through.
Okay.
Thank you.
Can I give you a hypothetical? It's not really a hypothetical because I happen to have 2 clerks in my chambers this year who are engaged. So in looking at this case and preparing this case, I looked at their websites. And so the hypothetical is about, like, I'm going to call it the standard website. They both have their names on it, the date of the wedding, a picture of the couple. Then there are a bunch of places that you can click to. And one is the schedule of events, and the other is travel and hotel arrangements, and another is favorite things to do in town while you're here, and another is registry. So that's what most websites look like, yeah? And they're not particularly ideological, and they're not particularly religious, they're not particularly anything, all right? And then there's a tagline, just like the tagline in this case, about sort of who created the website or whose graphics and design and typefaces and so forth were used in the website. And so one of them says, I'm going to substitute a woman's name just to not advertise, but one of them says, made with love by Amber, right? Mm-hmm. It's actually bigger than the 303 tagline. So I guess what I want to know is, suppose Amber wakes up tomorrow morning and says, you know what, I don't want to do those websites anymore for same-sex couples. Could she do that?
In terms of creating new websites?
No, you know, like she's providing these templates, and she has all these designs and typefaces, and that's what people use when they create their own website, because they give her the date and they give her the list of hotels and so forth. So can Amber wake up and just say, no more gay couples?
She can't say no more gay couples, but a speaker does have the ability to decide not to speak under the law. But I think the hypothetical that you're mentioning is assuming that it's a plug-and-play website, essentially, that the website is already made and that the speech creator isn't making any additions to it.
No. I mean, just like, I have to think that your client does something similar. You have lots of graphics, you have, typefaces, and, maybe, some are a little bit more you talk to the client, and some are a little bit less you talk to the client. But basically, clients are coming in and they're saying, we just want a standard website, that tells people where to stay and how to travel there, and what our favorite things to do are. And the question is, can a website designer say, sorry, that's not my kind of marriage?
The website designer...
There's no scripture, there's no ideology, there's no nothing.
There is ideology, and this court has already recognized that there is ideology and different views on marriage, and the court's promise in Obergefell is to protect those who would believe marriage is between a man and a woman from having to express a view that violates their conscience. But
so I think that, if I understand you, you're saying, yes, she can refuse, because there's ideology just in the fact that it's Mike and Harry and there's a picture of these 2 guys together.
That is speech. You are announcing a wedding, and if you believe the wedding to be false, then the government would be compelling you to say something that you otherwise wouldn't say, which makes it content-based.
So it's really nothing about the content of this speech. I mean, it could be Mike and Pat, and you don't actually even know whether Pat is a woman or a man. There's really nothing about the content of this speech. Am I right? In your case, you have like scripture examples, and so that might, be different, maybe. But you're being forthright and saying it's really not about that. It's nothing about the content of the speech. It's just that the content is being whatever the graphics and typefaces and which hotels are, have been reserved for the wedding, it's being used in a same-sex marriage.
No, it's not about the use. It's about when a person is creating speech, it is what is the message that they are expressing. The Hurley framework asked this court to first look at, is there speech? And there clearly is. Words, graphics, text, videos, pictures, that's speech, and it's generally protected. The second is to ask, is the speaker's message affected? And when you're requiring a speaker to create a message to celebrate something that they believe to be false, you're compelling their speech and it's affecting their message.